Imagine that it's November 2024 and election day has come and gone. The Kornacki cam has been put back into storage. All the states in a Trump-Biden rematch have finally been called. And the outcome is just about the same as it was in 2020, with Joe Biden winning the popular vote and carrying key swing states like Pennsylvania, Georgia, Michigan, and Arizona. America gets 4 more years under President Biden, right? Not so fast. Imagine for a moment that this time round, Georgia's Republican state legislature announces it is going to overrule the will of its own voters and award the state 16 electoral votes to Donald Trump. And not just Georgia. Imagine more states with Republican legislatures follow suit. Soon enough, more than 80 electoral votes have flipped from Biden to Trump in places like Georgia, Michigan, Arizona, which would be enough to ensure that Trump, not Biden, is then sworn in on January the 20th, 2025. It might sound far-fetched to you. State legislatures don't have that kind of unchecked power when it comes to elections, you say. There are safeguards, you declaim. There are courts to overrule all this, you remind me. There are principled office holders like Brad Raffensperger, who stood up to Donald Trump's pressure last time round, you shout at me. But what if those guardrails were gone? All of them. Because consider this. Last week, the Supreme Court said it would take up a case called Moore v. Harper, a case that should keep us all up at night. The Moore in Moore v. Harper is this man. Meet Georgia House Speaker Tim Moore. He's a propagator of Trump's big lie, who says Georgia state's courts should not have the power to reject gerrymandered congressional maps produced by his legislature. But his bigger and even more dangerous argument is that the state's courts, including the state Supreme Court, shouldn't have power at all when it comes to federal elections. So he's asking the U.S. Supreme Court to back a legal claim that state legislatures have basically unchecked power when it comes to organizing federal elections. If that sounds familiar, that might be because it was part of the groundwork for the Trump campaign's brazen attempt to overturn the 2020 election result. Trump lawyer John Eastman tried to argue that the so-called independent state legislature theory gave state lawmakers the power to throw out the results. Back then, his arguments were laughed out of court. But a fringe version of it has actually been around for a while. Then Chief Justice William Rehnquist nodded to this weird radical idea in his concurrence for Bush v. Gore, the case that decided the 2000 presidential election. But it didn't get much attention from the highest court in the land until this March, when 4 of the court's conservative justices said the court should take up the matter, should discuss it, rule on it. Quote, "We will have to resolve this question sooner or later, and the sooner we do so, the better," Justice Samuel Alito wrote back then. And now the court is planning to take up the case. That's how quickly the 6-3 conservative majority is moving. This spring, a federal judge slammed John Eastman's plan to reject electoral college votes as, quote, "a coup in search of a legal theory." That's how little that judge thought of Eastman's arguments. Let's be clear. The arguments that Eastman assembled were nonsense. They were based on fringe nonsense. But come 2024, those arguments, those ideas that Eastman was ludicrously pushing, well, they could have the backing of the U.S. Supreme Court. Joining me now, Leah Littman, assistant professor at Michigan Law School and co-host of the Strict Scrutiny podcast. She co-wrote an op-ed in the Washington Post this weekend titled, "A New Supreme Court Case Threatens Another Body Blow to Our Democracy." And still with me, Adam Serwer, staff writer for The Atlantic. Leah, what is your biggest fear when it comes to this case?
My biggest fear is that the Supreme Court is about to take a theory that was pioneered by the Bush campaign in 2000 and was a fringe theory that no one took seriously and is going to say it is unconstitutional. It violates the federal constitution for state courts to protect voting rights in federal elections. That would make our constitutional democracy so much less democratic at the very moment the Supreme Court is returning such important issues and fundamental rights to the political process.
And Leah, just to be clear, because in your op-ed you seem to suggest that even if the court did embrace this radical, once fringe notion of independent state legislature theory, those legislatures, GOP-controlled, would not have the power to appoint their own electors, or would they? Because a lot of experts like Michael Luttig, the judge who testified in front of the Select Committee, and Lawrence Tribe, former professor at Harvard, they say they will have the power to do that, and that's why our elections, our democracy, could be gutted come 2024. Where do you stand on that?
So the idea that legislators could throw out votes that are already cast is a warped variant of the theory that the Supreme Court is being asked to adopt in this case. Technically, the issue in Moore versus Harper is whether other institutions within the state, like state courts, can protect voting rights before an election occurs. It would be another issue, a separate case, whether state legislatures have such plenary control over elections that they could throw out votes that have already been cast. Now, obviously, these theories are related. Both rest on the idea that state legislatures have total, unchecked plenary authority, but they are distinct issues. One is about whether other institutions within the state can protect voting rights before an election has occurred, and the other is about whether state legislatures have such plenary control they can ignore the votes that have already been cast once an election is underway or has occurred.
I guess, having lived in the United States for the past 7 years, I'm always going to assume the worst variant is what's going to happen. Adam, you wrote recently about the court in the Atlantic. You said, quote, "The current majority's approach is itself a kind of undead constitutionalism, one in which the dictates of the Constitution retrospectively shift with whatever Fox News happens to be furious about. Legal outcomes preferred by today's American right conveniently turn out to be what the Founding Fathers wanted all along." And I guess we're seeing this across the board. We saw Clarence Thomas the other day invoke some weird QAnon-ish conspiracy theory about fetuses when it comes to the COVID vaccines in a ruling. We're now seeing justices bring forward this debunked, it's not even a theory, this idea that state legislatures can throw out votes. They really are just following a kind of right-wing media echo chamber script.
Well, I think it's unquestionable that the media that the justices consume shapes their perception of constitutional issues. I mean, in this case, it's almost, I mean, it's a little reductive to say the question is democracy constitutional? But to some extent, that's really what we're talking about here. You know, if the point of democracy is that the voters can change their mind. And what happens every few years is we have, you know, parties try to gerrymander themselves into electoral proof majorities. And sometimes the courts say, no, you can't do that. And this is essentially, you know, the definition of one man, one vote, one time, in the sense that what these legislatures are trying to do is trying to say, you know, we can entrench ourselves in power, election-proof ourselves from the voters so they can never change their minds, and then remain in power forever. And that defeats the entire purpose of democracy, which is that people can change their minds, they can decide to throw the bums out. And what is happening here with this case is essentially an argument that the Constitution prevents. In my view, it is essentially an argument meant that the Constitution prevents voters from picking their government, which defeats the entire purpose of our system of government, even as it hides itself behind the cloak of constitutionalism. It's really absurd. But it is an example of what you were just talking about, which is just this sort of imbibing of the most radical elements or radical arguments that float across right-wing media. The justices imbibe this stuff, and to some extent, they take it seriously. They don't always, but sometimes they do, and it has serious consequences.
I mean, gerrymandering itself is fundamentally anti-democratic in my view. And this idea that state legislatures can then use the majorities they've created through gerrymandering to keep themselves in power is outrageous on so many levels.
Perpetual.
Leah, let me ask you this. You're a law professor. I do not envy your job right now, teaching students about our system, about the great ideals of the American separation of powers, about a court that is theoretically neutral and independent and non-partisan and non-political, which is all BS, I'm sorry to say right now. I mean, this fringe theory, as you mentioned, came up in Bush v. Gore in 2000. Bush v. Gore is where Brett Kavanaugh was arguing on behalf of the Bush team. Amy Coney Barrett, I believe, was doing research in Florida. And John Roberts was giving advice to Jeb Bush, the then governor of Florida. Wonder where all three ended up 22 years later. I mean, the whole idea of this court not being political seems to be the biggest, like the most weird thing that we're expected to carry on believing. How do you teach that right now?
No apologies are necessary. I think it is important for people to learn more about the Supreme Court, because the more that they learn about it, the more they will be informed about what role it is actually playing in our constitutional system. I think it is completely right that this current Supreme Court is just discarding well-established precedents, is ignoring constitutional text, is ignoring the text of statutes in order to advance the Republican Party's agenda. And they're doing that in part because these lawyers were cultivated, within the conservative legal movement. They worked on behalf of the Bush campaign. And of course, it's no coincidence that the Supreme Court is about to adopt an argument pressed by the Bush campaign after 3 of the Bush campaign's lawyers, are on the Supreme Court, or 3 of the lawyers working with the kind of Bush circles are on the Supreme Court. So I think it is as important a moment as ever for people to learn a lot about what the Supreme Court is doing now and what the Supreme Court has done over the last 200 years, so that they can, increasingly have a voice in what they think the role of the Supreme Court should be in our constitutional democracy, because it's certainly not the one that it is occupying now.
Indeed. And Adam, it depends. We need Democrats to come out and say this, to question the court and not simply be institutionalists who defer to whatever a rogue court does. And yet, have a listen to Health and Human Services Secretary Xavier Becerra on Meet the Press over the weekend.
Is there any avenue you found that can actually expand abortion rights in places that it's going to be taken away?
Chuck, if you look at our laws and the way we administer them, when the Supreme Court speaks, unless we're all going to say that the word of the Supreme Court will no longer have value, we have to heed the word of the Supreme Court. And so we will, but we will continue to find every avenue possible to make sure women have access to the care that they need, including abortion care.
Why can't Democrats just say, actually, this court is pretty illegitimate? Why keep deferring to the idea of this neutral, above all else court? And why act like they have no power to do anything about it? The Congress actually does have the power to restrict the court's jurisdiction, and the Congress and the president have the power to expand the court, should they choose to do it.
I think it's an interesting question, because part of the way that the conservative legal movement took over the court was by attacking it as illegitimate. By mobilizing conservative voters against the decisions of the court. I mean, those impeach Earl Warrensteins came out in the 50s. Like, the Democrats are in some ways acting like these small C conservatives here, attempting to preserve respect for American institutions like the Supreme Court when they have already ceded any respect they are actually due by acting in the way that they have acted. So I think, I don't really have an answer for what the optimal political strategy is against this court. But when you see Republicans talking about how Democrats need to respect the court, the way that they won this fight was by not respecting the court, was by questioning the court's decisions, was by attacking the court as illegitimate. So for them to say now, Democrats have been attacking the court as illegitimate, they did that for half a century. And that's how they won this battle. So Democrats should not be afraid to at least rhetorically attack the court's decisions in that way.
Sadly, they are afraid. Quick last question, Adam. 30 seconds left. I have to ask, though. You had that back and forth with Justice Alito last fall, where he accused you of making false and inflammatory arguments about their approach to abortion rights. He said the court's not a dangerous cabal. How does that conversation, that back and forth, feel now, 6 months, 8 months later?
To be honest, I feel the same way I did then, which is that Alito is a liar. He will lie to the public, and he expects you to accept his lies as truth, because the Supreme Court is used to a level of deference that it does not deserve. And my job is to tell the truth, regardless, as I say it, as best I can. And, if that means that Justice Alito is going to get mad at me, one of the most powerful people in the country, well, then fine. I don't care. Because what he was doing was consciously misleading the public and demanding that I do the same thing.